California has some of the strongest worker protections in the United States, but enforcing your right to overtime pay requires evidence. Under California Labor Code Section 510, any work beyond 8 hours in a day or 40 hours in a week must be paid at 1.5 times your regular rate. Work beyond 12 hours in a day must be paid at double time. Yet millions of dollars in overtime wages go unpaid every year because workers do not know how to prove their hours. This presentation gives you 3 evidence tips that win cases. Whether you file with the California Labor Commissioner's Office, pursue a Private Attorneys General Act claim, or file a lawsuit in California Superior Court. California Labor Code Section 510 establishes daily overtime. This is stricter than federal FLSA law. The California DLSE at dir.ca.gov/DLSE accepts wage claims for unpaid overtime with 21 field offices statewide. The Private Attorneys General Act under Labor Code Section 2698 allows workers to sue on behalf of the state. You must file a wage claim within 3 years under CCP Section 338. Start documenting today. Evidence tip number 1. Your daily time log is your most powerful evidence. The single most persuasive piece of evidence is a contemporaneous daily time log created at the time the work happened. California courts give substantial weight to time logs because they are more reliable than memory. Under the burden-shifting framework, once you produce a credible time log, your employer must produce their own records to rebut it. If they cannot, the court can accept your log as evidence following Anderson v. Mount Clemens Pottery from 1946. Start a daily time log today using a notebook or app. Record your clock-in time, lunch break, and clock-out time every day. Consistency makes it credible. California law requires employers to keep records under Labor Code Section 226, but many fail to do so. Your log fills the gap. Let us now understand California's unique overtime rules. California overtime law is significantly more protective than federal FLSA law. Under California law, overtime is calculated daily, not just weekly. You could work only 3 days in a week and still be owed overtime if any day exceeded 8 hours. Under Labor Code Section 510, any work beyond 8 hours in a single workday is overtime at 1.5 times pay. Double time applies for work beyond 12 hours. Under Labor Code Section 511, alternative workweek schedules may be adopted. Under Section 226.7, if your employer fails to provide meal or rest breaks, they owe 1 hour of additional pay per violation. Your time log must capture all of this. Evidence tip number 2. Save every pay stub and wage statement. Your pay stubs are your employer's own admission of how they calculated your wages. California Labor Code Section 226 requires itemized wage statements showing gross wages, total hours, deductions, and net wages. If your stub shows fewer hours than you worked, that discrepancy is direct evidence. Save every stub, even incorrect ones. An incorrect stub showing 40 hours when you worked 48 is evidence of misclassification. Under Section 226E, you can recover $50 for the first violation and $100 per subsequent pay period, up to $4,000 plus fees. Compare your stub hours against your personal log. Request payroll records in writing. Employers must respond within 21 days. Evidence tip number 3. Capture your digital evidence. Your digital footprint is a goldmine. California courts rely on text messages, emails, scheduling app data, and GPS history to prove when work was performed. Take weekly screenshots of your schedule from platforms like When I Work, 7 Shifts, or Kronos. Emails about staying late and texts approving overtime are admissible. Save them to cloud storage, not on your work computer. GPS from Google Maps can prove you were at the work site earlier than your timesheet says. IT login records also show when you started work. California's unfair competition law and PAGA allow recovery for off-the-clock work beyond just overtime. Now, let us talk about your legal path. California offers 3 main enforcement routes. First, a wage claim with the DLSE. No lawyer needed, free, up to $50,000. Second, a PAGA action under Section 2698, where you sue on behalf of the state. Penalties of $100 to $200 per pay period. PAGA bypasses arbitration agreements after Viking River Cruises versus Moriana from 2022. Third, a private lawsuit in Superior Court for unpaid wages, overtime, meal penalties, and waiting time penalties under Section 203, an extra 30 days of pay. Attorney fees are recoverable under Section 218.5. File evidence with the DLSE first, then consult an attorney. Protect yourself. California's anti-retaliation laws are among the strongest in the country. Under Labor Code Section 1102.5, It is unlawful for an employer to retaliate against you for reporting wage violations to a government agency. Under Section 98.6, it is explicitly unlawful to fire or discriminate against anyone who files a DLSE wage claim. Remedies include reinstatement, back pay, and up to $10,000 in penalties. PAGA also protects filers under Section 2699G. If retaliation happens, document everything and file a complaint immediately. Know your rights. The law is on your side. Your 3-step action plan starts today. Step 1. Build your evidence package. Start your daily time log. Gather pay stubs from the last 3 years, screenshot your schedule, and save digital communications. Request payroll records from HR in writing. Step 2. Consult an expert. Contact the DLSE at dir.ca.gov/DLSE or call the Workers' Rights Hotline at 1-833-526-4636. Find an attorney at kayla.org. Step 3. File your claim. Choose the DLSE for free processing up to $50,000, PAGA for systemic violations, or Superior Court for maximum recovery. California recovered over $100 million in unpaid wages in 2023 to 2024. Your evidence matters. Start today